Hutton here.
My Lords, I represent the appellant in this matter, my learned friend Mr Riley Smith, represents the respondent. My Lord, may I start with some housekeeping matters?
Yeah, before we do that, just so that you and your client knows, we've had the opportunity to read the papers quite extensively. We've had plenty of pre-reading time. And although the grounds are quite long, there are really 3 short points. So we can't imagine this is going to take the estimated 2 days. We'd hope to conclude it today. So I don't know if you and Mr Riley Smith have got a timetable.
Well, my Lord, I was aiming to finish certainly with an hour after lunch, but I can endeavour to finish.
Well, we'll see how we go,
by
actually. Yeah,
lunchtime.
right. Do you want to do the time, tell you?
Yes.
The housekeeping.
The housekeeping, my Lord. So there should be a core bundle, a supplementary bundle, and an authorities bundle.
Yeah.
My Lord, some additional material was sent to the court on Friday afternoon, which I believe has been inserted into...
I doubt that. I mean, I saw it and I read it on Friday. I can't now remember what it was about.
Yes, my Lord.
But the message I got was that hard copies are going to be brought today, yeah.
Yes, my Lord. So there are 3 additional tabs at the back of the supplementary bundle, which if I could hand those up, together with a replacement for pages 243 to 245 of the supplementary bundle, and a replacement chronology.
And what are they, and were they before the judge below?
They were before the judge below, my Lord. The chronology is updated and with bundle references.
Right.
So if I just explain those, my Lord.
Thank you very much.
So, my Lord, starting with the tabbed material. Tab 14 is the notice given once the TROs in question have been made.
So this is the notice they're making, because they're not in the bundle, because I looked for them, but they were before the judge.
They were before the judge. They were handed up to the court.
Right.
The tab 15.
And this is orders 1 to 4, or just one of them?
They're orders 1 to 4, my Lord, yes.
Oh, yes, because it is, yep, okay, I got it, yep.
Then tab 15, my Lord, is a report to the Respondent's Executive, 30th May 2023. So that was on the old scheme.
The scheme before it was de-scoped.
Before it was de-scoped.
Which some of us would think means altered or reduced. But rescoped is becoming common language, yeah.
Political
yeah, and then there's the erratum.
And then there's the erratum to my skeleton, my Lord. So obviously that wasn't before this judge. And then, my Lord, there's a replacement for pages 243 to 245 in the bundle, which are the overhead Google Earth images. And the reason for that is just that when the bundle was prepared, for some reason the annotations have been left off. So it's just to correct that.
Oh, there's no hope. Oh, sorry. Yep.
And then at tab 7, the updated chronology goes into the tab 7 of the core bundle. My Lord, that has simply inserted the bundle references that were erroneously omitted. And my Lord, it's also been updated simply to make the court aware that some decisions took place after the challenge to the TROs, but my learned friend doesn't rely on those to defeat this appeal. So, for example, the making of TRO 5, which is currently under challenge, and also there was a further decision of the Executive on the 18th of November 2025, so simply to inform the court of that.
Well, you say inform, that strictly requires an application for new evidence. You're not informing the court, you're giving evidence, but there is an unagreed bundle which seems to include an application for new evidence. And the existence of T5 is a material factor potentially, because it could be relevant to discretion under 31(2)A.
Well, my Lord, my learned friend hasn't served a respondent's notice giving any reason.
Doesn't matter, we've got to do it of our own motion under section 31(2)A.
My Lord, yes. TRO 5 is currently the subject of a statutory challenge before the High Court.
So you say, but I've got no evidence of that at the moment. Anyway, we'll come back to it. And is this an application notice? Do you want us to deal with it now or later on?
No, my Lord, it's only that my skeleton informed the court that it would update the court as to the factual circumstances which had occurred, simply just updating your lordships. But it's, my lord, I don't rely on TRO 5 having been made. I don't rely on any further decision being made.
Right, so we'll see if my friend must rely on it, but updating is sometimes giving evidence, and that's different.
My lord, well,
Right, so that's all the housekeeping then.
that is, my lord. My lord, turning to my submissions.
Yep.
My submissions will follow the order in my skeleton argument,
Yep.
which I adopt. My lords will be aware that this is an appeal against the decision of Mr. C.M.G. Ockleton, dated 4th of August 2025, since he's a judge in the High Court. And in my submission, the TROs, which are the subject of the challenge, which were made on the 10th of January 2024, brought into force or operation on the 24th of January 2024, have, as a matter of law, implemented one element of the proposals promoted by the Council and known as the revised Harrogate Station Gateway Scheme. And, my lord, there's a fairly long history behind those proposals. And if I could start by making a few points on the original scheme. And my lords will have seen at tab 9 of the supplementary, sorry, page 9 of the supplementary, tab 1.
Yep.
The original scheme was that which is shown here in blue and also in red.
Yep.
A much broader scheme. That was originally approved by the Council on 25th of January 2022. That was subject to a challenge by Hornbeam Park Developments, and the respondent agreed not to implement the decision. There was then a further consultation on the scheme held on the 22nd of July 2022 to 23rd of August 2022, and separately a number of TROs published for comment. And on the 30th of May 2023, the respondent's executive resolved to make the TROs, prepare and submit a full business case, and proceed with implementation. And my lord, the report to the executive is now at tab 15, 30th of May 2023.
I only have a tab. Oh, it's the
new
ones.
yes, my lord, the new material.
Yeah.
And if I could simply highlight to the court.
This is the old scheme, though, is it?
This is the old scheme,
right,
but it forms context for the November 2023 decision.
Yeah.
The old scheme, one can see it, part 6 of that report, on page 3, how public consultation was dealt with. So one sees at 6.2 there was a first consultation, which was a very broad, dealing with initial feasibility. Second consultation based on preliminary designs. We have a reporting about how the levels of public support for the proposals, percentage terms. The third consultation at 6.4, again reporting in percentage terms the views of the public. And my lord, that extended, that concern about the views of the public extended into particular topics. So one can see that at paragraph 7.1. So dealing with the impact on businesses. And at 8.3, dealing with congestion and traffic flow. And ultimately, the outcome of the report was that the committee accepted the recommendation, which one sees on the first page of that report. That decision was then challenged by Hornbeam Park Developments on a number of grounds, including relation to consultation. The respondent consented to judgment on one ground, which was that one of the TROs ought to have been the subject of a public inquiry, and it did not defend the other grounds. So that completes the picture up until November 2023. On the 28th of November 2023, the respondent's executive considered a revised scheme for Harrogate, and that's at tab 1 of the supplementary bundle of the report. And if one turns to page 4 of the bundle, one can see the purpose of the report was to provide the executive an update on the North Yorkshire Transforming Cities Funds projects, including revised scoping. And one can see 3 recommendations, one for Selby, one for Skipton, one for Harrogate. And my lord, I just highlight at this stage that the recommendations were the same, save for the fact that the Harrogate recommendation required a satisfactory public engagement outcome.
Well, that's what we've got to decide, but the
Yes.
recommendation is at 15.
So the recommendations at page 4.
Well, 14 to 15, really.
Or 14 to 15. And one can see in the wording, so the last line.
Well, the first wording is the executive approve the
Yes,
de-scoping options, and then it is, you say, subject to conditions.
Yes, my lord. And then one can pick up the minutes, which are at tab 2.
Yeah.
One can see the resolution on page 20 followed the recommendation.
Yep.
My lord, the discussion for Harrogate in the report starts on page 8.
Yep.
4.13, discussing what the original scheme consisted of. And then, in light of 4.14, in light of the legal challenge, Council is considering potential to deliver a revised scheme. And then at 4.15, reporting on what elements might be included in a revised scheme. So, my lord, at this stage, actually what would ultimately be proposed was uncertain.
Is that correct? I know it's written like that in 1415, but my understanding of one of the arguments against you is when you read the recommendation that the de-scoping options outlined, i.e. what is in 1415 presumably, is approved or is recommended for approval.
Well, my lord, it's the de-scoping option, so there still had to be a development of the scheme, and one can see that at 4.16.
Sorry, let's take it stage by stage.
Yes.
Does the phrase approve the de-scoping options outlined for Harrogate refer back to 415 as a matter of fact, or is there a dispute about it?
My lord, I don't believe there's a dispute about this.
So what's the factual position then?
In fact, at this stage, it wasn't certain exactly what.
No, that's not the question that I asked.
Sorry, my lord.
It's a factual question, not a question for submissions at the moment. You're going to make those in a moment.
Yes, my lord.
I wish to know whether the phrase approve the de-scoping options outlined for Harrogate is a reference back to that in 415 or is not a reference back to 415.
Well, in my submission, it is.
It is.
Yes.
Right, so 415, 15.13 then refers back to where the de-scoping option refers to what's described in 14.15. We'll get to the legal significance of it,
Yes.
but just that we have the facts
Yes.
clear, and then we'll have the submissions separately. So I know what we're talking about then, yeah.
So my lord, but of course the resolution has to be read as a whole.
As a whole, yes.
So there was approval of the de-scoping options for Harrogate. Then, of course, the preparation and submission of the full business case with the detail delegated to the corporate director. And then
Well, you've got a number of sentences. The first sentence
Yes.
is approve the de-scoping options. That is approve paragraph 415. And then it says there's got to be a full business case, which in the event is approved by the West Yorkshire people, has got to be accepted, and they deal with that.
Yes.
There's a reference to acceptable terms and conditions, and they deal with that. There's a reference and for a satisfactory TRO and public engagement outcome, the scheme to be implemented.
Yes, my lord.
Yeah.
So the third sentence. So the scheme should only be implemented subject to being affordable, acceptable terms and conditions being received, and for a satisfactory TRO
Yeah.
and public engagement outcome.
Yeah.
My lord. And I just highlight that the public engagement outcome didn't apply to Selby, Skipton, but it did apply to Harrogate.
Yeah. And does it quash the implementation of the scheme, or does it mean no scheme has been approved?
Well, there's no authority to implement a scheme unless there's been a decision or that the scheme is affordable, satisfactory TRO, and there's a satisfactory public engagement outcome in my submission. Because this is prior to the TROs being made, this was the sole decision of the.
Yes, I understand that. Yeah. So no scheme has been approved then?
The de-scoping options have been approved, as in carrying out that process. carrying out the business case process, but the scheme should only be implemented subject to the provisos.
Okay.
And again, the context being that this is a scheme in development. And my Lord, note that at this point, because the scheme is in development, there was no information on actually what the impact of these proposals would be, what they would look like, and that would include the highways impact, but it would also include heritage impact, for example. This is located within a conservation area.
So a TRO, the TRO is a precondition to the scheme, then, is it?
The TROs had to be in place, yes, my Lord.
Before there could be
because they are the thing that implements the traffic
Well,
elements.
that's just in terms of timing.
Yes, my Lord.
There couldn't be a finally approved scheme, you say, without a TRO being in place.
My Lord, there could be an approved scheme, but it couldn't be implemented until the TROs are in place.
And I'm still not clear in my own mind whether you're accepting or not accepting that the scheme has been approved, and the scheme is the de-scoping options described in 415, but the implementation of that scheme is subject to the conditions. So if all the conditions were met, the council wouldn't have to go back and say, yes, we approve 415. They would say, no, we've already approved 415. It's the provisos that we're dealing with for implementation.
Well, exactly. So there still has to be that further decision for implementation.
Well, that's the question.
And the council at that point, of course, would have to consider the public engagement exercise, the affordability, any updated information on the scheme.
Yeah, we're at cross purposes, I think. The scheme has been approved, full stop. We know what it is, it's the de-scoping option. Will it be implemented? There are a number of provisos. In relation to each of the provisos, there will be arguments as to which body or which person is responsible for determining whether that proviso has been met. But we're only dealing with one proviso, which is the TRO. We're not dealing with the other ones.
Well, no, my Lord, in my submission, we're not, because of the legal effect of the TROs, which is that they implement the scheme.
Right, okay.
So, my Lord, just coming back to, so if I could just come back to 4.20 of the report.
Yeah.
So we see here, should the proposal, so 4.20, should the proposal to develop and deliver a revised scheme in Harrogate be approved, offers will recommence the development process.
Yeah.
Change requests prepared, submitted to the FT and WICA, including any changes within the North Yorkshire programme. And then part 5 deals with consultation undertaken and responses. And I particularly rely on 5.2 for what is understood by a public engagement outcome. So we see that first sentence, there'll be informal discussions with the ACC to ensure design is supported locally.
And the ACC, just remind me?
The Area Constituency Committee.
Right.
Well, it's made up of councillors.
Yep.
Proposes continue to ensure the design is supported locally. Period of public engagement, as well as any TRO public consultation required, is also proposed to understand the level of public support. And the outcome of this would be reported to the ACC. And clearly, the purpose of the engagement is to understand the level of public support. It's not to inform the public of the proposals. It's not to feed into the design. It's to understand the level of public support.
And is your submission that you can't have the TRO without that having been undertaken?
You can't have the TRO made and brought into force without that having been undertaken, because what it does is it, as a matter of law, implements.
So you cannot have the TRO made and implemented because you say, as a matter of law, it implements the scheme.
Yes. Once the TRO is made, my Lord, and with a date where it is brought into force.
Yep.
Under the statutory scheme, the council is required to put up traffic signs in order to bring it into...
And more accurately, if they don't put them up, they can't prosecute.
Yeah, well, yes, my Lord, but they are also required to put out the signs.
Yep.
So
Okay.
that's the preliminary step. So, my Lord, it's that paragraph which then feeds into, which in my submission informs what was decided as part of the resolution. The resolution which was recommended was that which was adopted. So, my Lord, in my submission, what was being required here in terms of public engagement was, in essence, a consultation. Because its purpose was clear, which was to understand the level of public support. And how can one do that without publicising the proposals, sufficient detail such that they're understood, seeking out representations?
Hold on. They need to understand level of support. Cannot do that without publicising the proposals. Yeah.
With sufficient detail such that they can be understood, without seeking out representations, views, and taking into account the product of that exercise. I mean, in essence, my Lord, those are the gunning principles.
Yep.
But, my Lord, even if I am wrong about the exact scope of what was required by public engagement, it is clear that the resolution contained a number of provisos, one of which was a satisfactory public engagement outcome.
Yes.
And so that requires a judgment to be reached by the council.
It's not the subject matter of this application under the TRO Act.
Well, in my submission, it is, and if I come on to the legal effect of the TROs and explain
All
why.
right, okay, so the resolution contained provisos, and what the TROs are conditional on the provisos being satisfied.
My Lord, yes, because they implement, because of their particular effect in law. My Lord, if I accept that if we were dealing with a planning permission, this would be a very different scenario.
Yeah, but you say you're not. You say the provisos have got to be satisfied because the implementation of the scheme is in effect the making and the bringing to force of the TROs.
Yes, my Lord.
Yep.
So, my Lord, after this decision had been made, there was then a separate process going on, which was the development of the business case
Yep.
scheme, and that was the application to the interested party for funding. And, my Lord, as part of that, the respondent was required to assess the impact of its proposals, and that led to a number of technical studies being carried out. And one of those reports became available to the appellant actually after this claim had been filed. It wasn't aware of them at the time.
Yep.
TROs were being consulted. And if I could start with the first of those, which is the local junction modelling report at tab 6 of the supplement. This is the local junction modelling report. And one can see it measured impacts at 2 sites. The plan is at 82 of the bundle, site 1 and site 4. Site 1 was just south of the new bus lane, and site 4 broadly towards the south of the scheme. The results of that are in part 6, page 106. And broadly, they showed that there was in all scenarios, a reduction in queue length by up to 9.2 metres. That's table 6.1.1 at the first junction. But then at the second junction, at junction 4, there was an increase.
Just remind me where junction 4 is.
Junction 4 is
To the south.
to the south, my lord. So page 82, just south of Albert Street, Station Square. And one can see the table.
And then you wanted to say the reduction in queue length for junction 1 or site 1
was
2.
up to 9.2 metres. Number of scenarios being tested. At junction 4, there was an increase in queue length in all scenarios. up to 57.5 metres, top of page 107. And then there's...
Hold on, this is technical, it's not what we normally do.
ma'am.
Let me just check that I've understood. So table side 4, comparison based on proposed scheme. And this is the de-scoping scheme.
Yes, my lord.
Yeah. Scenario number, traffic flow, cycle time, total delay, it's not clear what that is. Highest DOS, not clear what that is. PRC, not clear what that is. Highest MNQ, I assume that's to do with meter length. And you say what?
So my lord, what broadly it showed, and one can see this from the summary at 115, 8.1.11, and summarise the results. Essentially, there was an overall disbenefit to general traffic usage.
Well, 817, all model proposals were shown to work with a degree of saturation. 8.19, results show improvements in all metrics. And 8.11 would not have a significant impact on general traffic, and you'll tell me what they mean by general traffic in a minute. And then there's an overall disbenefit to general traffic users from the scheme. What does that actually mean, general traffic?
So, my lord, this is not specific, but the council accepted from the High Court that the journey times of buses would be implicitly caught by this as well.
I understand that. That's in your skeleton argument. My question is a different question. Is there a definition in this document of general traffic? Or if not, how do I know what it means?
My lord, I don't believe there is a definition of general traffic. I mean, my submission is, my understanding is that it is vehicular traffic.
Yeah, but you've got to put that conclusion in the context, for instance, of pages 107 and 108, where they're actually modelling the base against the proposed scheme. And for instance, in 6.2.5, DOS is a degree of saturation, isn't it?
Yes, ma'am.
Yes, and that's one of the figures expressed in it. PRC is percentage of reserve capacity, isn't it? I think.
Well, I believe that's right.
Yeah, I remember Linsig models from days of yore. And what they're saying is, in 6.2.5, there's an increase in queue length, etc. PRC, percentage of reserve capacity, is reduced, but the junction remains within capacity. Degree of saturation, total delay, shows an increase for the proposed use. More road space and cycle time is dedicated to active travel.
Yes.
So what this is not modelling is the benefit, and by active travel, we mean what we used to know of slow modes. What this is not explaining is what the impact on the attractiveness and use of slow modes may be as a result of the introduction of the scheme and the facilities for cyclists and pedestrians.
Yes, and I perfectly accept that, my lord. This is dealing with the vehicular traffic,
Yeah.
not...
And the
cyclists
scheme's
and
all
pedestrians.
about how do we make slow modes more attractive,
Well, my lord, yes.
as
but of
well
course-
as improving the quality of the urban environment by planting more trees, etc.
My lord, yes, but of course all of the impacts of the scheme have to be considered. And when we come to the test of the TRO...
Some may be more important to the decision maker than others.
They may well be. But my lord, the decision maker was not... This report was not drawn to the decision maker's attention. It wasn't taken into account. And one of the impacts is an increase in delays overall, because at Site 4, the disbenefits at Site 4 outweighed the comparative savings at Site 1 for vehicular traffic.
That last sentence I don't understand.
My lord, queue lengths were reduced at
No, I understand that. It's
Yes,
the
ma'am.
conclusion you draw, because you're comparing different things. And it depends, that's why I was asking about general traffic and disbenefits. There will be longer queues, which will primarily affect cars, but you say
Yes,
may
ma'am.
include buses. But the aim is to get more people to stop using cars and to walk or use cycles.
I
Well,
think the
that-
phrase general traffic would be understood, wouldn't it, to be vehicular
Yes,
traffic.
yes.
In other words, non-slow modes, cars, vans, lorries, buses,
Yes.
etc.
Yes, and that... Yes.
And the scheme will have an impact on vehicular traffic, which is not surprising, because its
Yes.
aim is to discourage or to encourage.
Well, except, my lord, that is not that is not in the report to the decision maker on the TROs, and that's the point. This is one. I don't say that this is an overriding material consideration, but it is a material consideration.
Well, yes. I mean, you say overriding material consideration. We have to separate out those words because the words have specific meanings in public law. And material consideration falls into two things: things that you are entitled to take into account, and things which it would be unlawful for you not to take into account. So what are you actually saying about this?
In my submission, it's an obviously material consideration, the effect which the TROs would have on general traffic. And I'll come to the statutory tests in a moment, but in my submission, that's supported by...
Okay. So you don't really need that report anyway, because you told me that one of the impacts might be an increase in overall traffic, and that's not in the reports on the traffic orders.
Well, but it's this report, my lord, that has put the appellant
your evidence for it.
Yes, my lord, exactly. My lord, in terms of bus journey times, there was an agreed note before the High Court.
About 12, I think, isn't it? Yeah.
Yes, my lord. There were, in a number of the documents, there were references to public transport journey times, and there was a lot of correspondence between the parties as to what that related to. But at paragraph 10, the defendant agreed that it now confirmed it doesn't have any separate specific report on the revised scheme in relation to bus journey times, although bus journey times were implicitly captured as part of the modelling reported in the WSP traffic modelling.
Is that what we've just looked at?
So that's what we've just looked at. And then, my lord, there were statements, insofar as they went, one sees a January 2024 business case.
But as I understand it, the Linsig modelling that we've just been looking at was based on a wider VISIM network-wide model, which presumably could have included coding for all types of vehicles. But what you're saying is that the council's understanding is that it didn't, the VISIM modelling didn't include across the wider network different coding for different types of vehicle.
That seemed to, my lord, it was very unclear as to what had actually happened, but the council accepted that the journey times were implicitly captured, and then where documents dealt with bus journey times, one can see it. So the January 2024 business case, which is cited in paragraph 11, reported slight disbenefits to public transport journey times due to overall increase in congestion.
Where did you get this? Are you in paragraph 12?
Paragraph 11.
Oh, 11, hang on. So some analysis was done of the bus journey times relating to the scheme in January for the use of traffic data. The January 24 business case states, due to an overall increase in congestion, as the benefits outside the peak periods have not been quantified, it is anticipated that these will counteract the disbenefits. Well, we have to look at it as a whole, don't we, Ms. Hudson?
Yes, my lord. Yes, my lord.
As a result, what it actually says is no benefits or disbenefits for public transport journey times have been quantified.
My lord, and that's what the economic assessment report said also, which is reported at, cited at paragraph 13. But
and interestingly, there wasn't a Paramix model, but it's derived from the Linsig modelling.
Yes, my lord.
Yeah.
Right, so what do you want us to look at in 13?
My lord, so at 13 a similar point was made in the economic assessment report, and one can see that at 3.4.2. Essentially saying some routes with benefits, some routes with disbenefits.
Well, no, I mean, you really must read things fairly, and it says overall there's little forecast change, and so no benefits or disbenefits were quantified. So whether or not there are any, it hasn't been quantified. That's what that says.
Well, my lord, first, the sentence before that, the results on both occasions showed a mixed picture.
Yeah.
Some routes benefiting, others showing a disbenefit.
Yeah, and that's why they say overall
yes,
there's no disbenefit, and they don't go and do any more because it's found to be negligible. One has to read the whole thing, Miss Hutton.
Well, exactly, my lord.
Otherwise, it's misleading.
Well, that's my point, my lord, because when one goes to the report, the only thing that has been reported is savings to bus journey times.
Right, well, take us
I'll
to
come
that.
to that. May I come to it in a moment? May I deal with these?
The report you say is misleading. because it says bus advantages.
Yes, my lord.
Okay, so that's the second point, bus journey times. So we've got bus journey times, we had traffic generally, yes. And next?
My lord, safety.
Yep.
So as part of the business case process, the designs were subject to quality review by the interested party. And my lord, tab 9 of the bundle is the outcome of that review.
Yep.
Sorry, tab 9.
Tab 9, my lord, page
which
144. Oh, it's supplementary bundles.
Not easy to read.
No, I apologise, my lord.
Indeed, I would say almost unintelligible at the moment.
My lord, if it would help, I can type out. I'm afraid I did try to print it larger and couldn't do that.
Well,
No,
if it can't be done, it can't be done. But if I can't read it, it's hard.
My lords, my apology for raising. I'm told because of that we've bought some copies with enlarged text that is readable.
Okay, yes, because otherwise, if we can't read it, I don't see, with the best will in the world, court can only work.
Whilst those are being produced, can we just identify what this is part of?
So, my lord, as part of a quality review process, which is looking at the safety of the proposals. So looking at road safety, this was the front page of a long Excel spreadsheet, which is even more difficult to print and read. But what it showed was an iterative process by which the designs are refined and refined and refined, and the quality review panel are commenting on concerns that they have, raising queries, etc. So it's effectively a design review with a particular focus on the safety of the proposals.
And when you say design review, what does that actually mean? Does it mean somebody's commenting on the design, so if it's not safe, you change the design so it is
That's
safe?
that exactly what has happened. And this was the final report prior to the making of the TROs.
Right.
And so, and one can see one sees the summary, one can see what's happened in terms of the iterative proposal.
How does this relate to the safety audit we've got at tab 4?
It's a different process, my lord. So the road safety audit was external consultants being commissioned to review the scheme in a usual road safety, and this was then the internal West Yorkshire Authority reviewing the scheme. So my understanding is there were two different processes.
Right, so what do you want us to get out of this? Where do you want us to go?
So, my lord,
Bearing in mind we've got to read it fairly and read the whole thing
Yes,
if
my
it's
lord.
relevant. Yes,
Well, my
not
lord,
sentences out of context.
can note when one goes to the summary, which is the bottom of the first page, the second paragraph just details that point that there was initially 24 concerns.
This is the third paragraph. Actually. The review initially identified 24 concerns, yes.
So, and then one can see through the process, the penultimate paragraph, process of providing traffic flow and scope info, engaging redesign, the scheme has two concerns remaining, one critical issue and one policy issue. And the critical issue is then described as in relation to separating out cycle movements in time and space to avoid cyclists mixing with traffic.
Yeah.
And the penultimate paragraph, so that the team acknowledged that the scheme will introduce enhancements for pedestrian, cyclists, bus users, improvements in terms of safety, ease of moving through the area and general experience. And then despite the positive impact the scheme is expected to have, there is still one unresolved.
So it's going to be better for safety, but it could be better still.
But there's one, the interventions will still remain one unresolved.
Can I repeat my question as to in terms of the design feature, where that's referenced in the WSP safety report? think it might be at page 43, but I'm not sure.
My Lord, if I may assist, that's our understanding.
Yeah. So this is the point that WSP had identified as an issue in relation to the potential conflict between cyclists and southbound traffic at that junction, and the question of whether or not vehicles might take a racing line and cause issues in relation to conflict with cyclists. And their recommendation was that that would be resolved by additional signage and information being provided to drivers to warn them that there's a potential for cyclists to be ahead of them if they take the racing line contemplated. So this is a different conclusion, isn't it, from the one that's been reached in this report?
My Lord, if it is exactly the same problem, then yes, it is a different
Yes.
conclusion. And this was reached in
July.
July.
Yes, and so either the authors of this report were unaware of the earlier safety audit work that had been done, or alternatively they formed a different view. But the information before the council was not necessarily unequivocal that this was a critical issue which was incapable of being resolved.
Well, except my Lord, except what it did have was a independent body.
Well, the whole point of going to WSP is a completely independent.
Well,
safety audit process is designed so that engineers completely independent of the development of the project are parachuted in to provide a review to make sure that the issues that the designer might have overlooked or which the designer is concerned about are audited.
yeah, but I'm not saying that WSP weren't also independent, but WICA are independent as well, and had reached a view that there was a critical safety issue.
But as I understand it, on safety, where we've got to is this, we've been shown, or we've looked at two documents. One you started with says there are improvements in safety, but there's one outstanding concern, to put it neutrally. We've got another document that we're told covers the same area of concern, and it recommends a particular solution to do with signage, or what I used to call signs.
Yes,
And that's it.
yes, my Lord. If I could then turn to carbon impact.
Yeah.
My Lord, if I could ask your Lordships to turn up tab 8 of the supplementary bond.
Yep.
And it starts with a summary, but if I could turn to page 129.
Yeah.
One can see it's dealing, so modal shift, and the third paragraph to active travel.
Mm-hmm.
So this is predicting a decrease of 185.4 tonnes.
I assume that's because there'll be less emissions from cars and more people pedalling like fury.
No, my Lord. So this is dealing solely with the switch to active travel modes.
I thought that was people cycling and walking.
But sorry, what it doesn't include is the traffic changes in general traffic. So if one looks at the bottom of the page.
But we'll get to that.
Yes, my Lord.
But there's a modal shift to active travel, which put into English, I thought meant less people are driving and more people are walking and cycling.
Yes, my Lord. Sorry, my
So therefore, you aren't having car emissions because the people that were previously driving are on a bike or walking. That's what I thought modal shift meant in English.
You're not having those car emissions.
No, exactly.
But the slight clarification comes from changes in general traffic.
Well, we'll get down to there in just a minute. But that's what that says, is that there's going to be that saving by the switch from cars to non-cars.
Yes, my Lord.
And it's hard for me to understand it, but that's based on a reduction of vehicle mileage by 3.263 million, is it?
But
Over 60 years.
by 185.4.
No, that's the measurement of the carbon emissions, but that's done on the basis that there'll be 3.263.
Oh, I see, my Lord. Yes.
Is that what it means?
Yes, that's what it means.
So
Yes.
there'll be 3.3 million kilometres less driven, and then you go on to changes in general traffic,
Yes, my Lord.
which we assume is cars and buses and vans.
Yes. So those who are remaining under this proposal in their cars, buses and vans, we see the proposed scheme expected to result in an increase in vehicle kilometres.
Yeah. But only of 2,000 as compared with 3.263 million that we've saved, according to them. And then they say that because you've got 2,000 kilometres more, I don't know whether they're taking longer journeys, that'll lead to 426, whatever that measurement is. And I find it hard to understand how if you say 3.2 million kilometres, the reduction is only 185. But if you increase it by just 2,000 kilometres, you get an increase of 426. But then who am I to express a view? But you see my difficulty.
I can see that, my lord. I mean, the clear conclusion is that the changes to general traffic.
Is that traffic growth?
No, my lord, I don't understand it is. If one looks at change of vehicle kilometres at junction 1,
Yeah.
which is likely because of rerouting.
I can see some shaking of heads as to whether or not it is or it isn't traffic growth. I think it's quite an important point, because if this is kind of tempo-like traffic growth, then this is going to happen in any event, isn't it?
But,
it's not an effect of the scheme.
My lord, the report explains what it is.
Mm-hmm. Mm-hmm.
It explains that this result is due to the change in vehicle kilometres at junction 1, which is likely because of rerouting. So that's the one-way system. Additionally, junction 4 has an adverse carbon impact from changes in speed.
You're slowing down and changing gear.
Exactly. Stop-start movement.
But what I don't understand is how 2,000 kilometres translates into an amount of 426 whatever, but 3.2 million kilometres is far less. That's what I just don't understand, Ms. Hudson. Do you see my problem?
Yes, my lord, I can see that. I can see that point.
So I then wonder what I'm supposed to do with that. Anyway, so that's that.
But my lord,
and then you go on and you see that construction makes a big contribution too.
Yes, my lord. So first you have the changes in general traffic.
Well, no, first you have the modal shift.
Yes.
Then you have the changes in general traffic.
Yes, but the point I was making, changes in general traffic predicted on the face of this report to be more than double the carbon savings from modal shift.
Well, that's what I don't understand, though, the figure that...
No, my lord, and again, this wasn't before the decision maker, and it's difficult for me to explain that.
But anyway, I see the figures there, and I raise an eyebrow, but maths was never my strong point. And you go over the page, so we've had two things now, and we're going to get a third thing in a second, which is the carbon emissions from construction.
Yes, my lord, and that's the infrastructure carbon.
Yeah.
Again, greater in order of magnitude to the savings, and then one has the conclusion on net impact at 131.
And that says the increases result mainly due to the construction.
Construction, but also important in my submission, my lord, that when one just looks at the user emissions are overall an increase as opposed to a decrease in carbon.
Yeah.
And then
it goes on to say that this adverse carbon impact is justified because, in its view, the scheme accomplishes the overarching vision for the development.
Yes, my lord, that's the view of the author of that report, is it's justified as it accomplishes overarching vision for the development. But that conclusion doesn't displace the quantitative assessment, which is that overall negative
Insofar as
carbon
intelligible,
impact.
yes. Okay.
Is this a modelling of network-wide effects, or is it a modelling simply of the effects of the scheme itself?
Well, my understanding is that it was the scheme itself.
So if I live on the outskirts of Harrogate and am encouraged to use my bicycle by the scheme as part of the modal shift, the savings in carbon emissions that might occur earlier in my journey, prior to encountering the scheme, would not be counted in this. I mean, I'm just struggling to understand, because we haven't got the whole, I mean, maybe we have got the whole document, but I'm struggling to understand what is being modelled here in terms of the impact of the scheme, what's being modelled, full stop.
May I just check one?
Yes, of course. See, yeah, I mean, I don't know what I'm supposed to understand by on page 129. Benefits and loads beyond the system boundary at the top of the page, which are, I'm told, not quantified, but are part of a qualitative assessment.
Well, may I look again at
Don't-
this over
yeah.
lunch?
Don't do it
I
now,
don't
yes.
want to
Well, if
miss
Just,
necessary, yes, I'm hoping we'll
If
be
necessary.
finished by then, if necessary. So those are your 4 points on the technical things to which you wanted us to draw attention in the material.
It is, my lord, but
Yeah.
my submission just on that point about what this is, it's never been raised against me that this is irrelevant or wouldn't have made a difference because of the particular calculation it had carried out. Because there was some intricacy in the calculation which meant that it was somehow less relevant to the TROs.
Right.
So I'll leave that there and I'll read through it
So
carefully.
you've shown us 4 things, and your main point is these were not taken into account by the decision maker.
Yes, my lord. And I'll come on to underground 3. In fact, in my submission, representations were made which were contrary to the conclusions of those reports. So, we're coming back to the chronology of the TROs. The Lordships will have seen that there was publicity in July and August 2024, when there were 6 TROs published. The Appellant and a number of others weren't aware of it at the time, but they later made representations. And my lord, if I could just highlight the objection letter from the Appellant.
Well, take us to it. We don't need to read it. He's
No,
made his
SP7,
objection.
the short point is that it made the point that issues of journey times, congestion, safety and carbon required technical assessment. And that's paragraph 2.13, page 122, 2.15 and 2.16 on 123.
So 2.13.
2.13, 2.15,
Yeah.
2.16. Of course, at that point, the appellant was unaware of any.
Of these things, yeah. Okay.
So then there was the decision to make the TROs, and that's at tab 10 of the bundle.
Yeah.
And the first overarching point,
Sorry, could I have that reference again?
tab 10, my lord, page
Yeah.
145, starting at page 145. And one can see the purpose of the report is at 147, to advise on the outcome of the consultation. And one can see that the TROs, their sole purpose is to facilitate what's called the revised Harrogate Gateway Scheme. At one point.
Sorry, were you getting that to us?
At
So
one
the purpose is to advise on the outcome of the public consultation and a decision on whether to proceed with the making of the orders in view of the comments received.
Yes, my lord, at 1.1, TROs are to introduce a range of TROs to
To
facilitate.
facilitate, yes.
Yes, my lord. And then at 2.2, having described at 2.1 what the revised scheme is, 2.2, it's necessary to introduce new TROs to allow for these improvements.
Yeah.
And then the second point is at 2.1, at 2.2, the fourth line from the bottom, sorry, fifth line. Having noted that there was a condition that prior to approval to proceed, the council must provide a progress update on the TRO consultation. And then it says, until this condition is satisfied, there remains a risk of uncertainty in relation to the confirmation of funding. It's prudent to update on the consultations and to seek decisions. So the short point is that it was not a condition of the funding that the TROs be made and in force prior to receipt of funding. The condition was simply a update on the process, progress update on the TRO consultation.
Well, in order to give a reassurance, I mean, you've really got to read everything. You can't just take sentences.
Yes, no, but my lord,
As this I'm just progressing in tandem with the project and funding approvals. Yes.
but the point is that the condition did not require the making of the TROs.
No.
Part 3 addressed the proposals and recommendations summary that set out the 4 TROs. And then, as your lordships will have seen, it was proposed not to make TRO 5.
Well, that's not, again, accurate, I'm sorry. Not to make that TRO
TRO
in that
5,
form,
yes, my lord.
but to reconsult because there were changes.
Changes, exactly.
I thought they weren't going to make traffic order 6 at all.
Yes, my lord.
So they are going to, or they planning to make
They're planning
TRO
to make
5,
it.
yes.
But on that, as at that decision, TRO 5 was not to be made. It was
Not to be made on that occasion, no.
On that occasion, it was to be
But nor
made.
was it not to be made.
Well, no, my lord, but it was. But ultimately, it was to be the steps in requirements with Regulation 14 were to be carried
Yeah.
out. You can see that at paragraph 12.
Yep. So 4 were to be made, and the 5th to be reconsulted on with a modification.
Yes, my lord. And eventually, TROs 1 to 4 were made, but not TRO 5. And my lord, if I just turn to what the effect of making TROs 1 to 4 is, tab 13 of the bundle, the supplementary bundle, got page 263 are the TROs.
Yep.
TRO 1 starts at 263. One can see it comes into yes, paragraph 8 on page. Apologies, it's the core bundle.
Core bundle. So.
Core bundle, my lord. Apologies.
Yep.
Tab 4, it's the back of the core bundle, tab 14.
I've got the core bundle in 2 volumes. Yep. Yep.
TRO 1, paragraph 1 on page 540.
So can I just check? It's made on the 10th of January,
Yes, my lord.
and it's to come into effect, it says 14 days later. Well, come into operation, whatever that means,
Yes,
on the 24th,
24th of January
Yeah.
2025. And paragraph 8 on page 543 designates the bus lane in operational times.
So I don't have a paragraph 8.
Page 543, my lord. I think the last page has been printed out of sequence.
Oh, right, okay.
So paragraph 8 designates the bus lane.
Yeah.
Paragraph 9 prohibits vehicles being within the bus lane save for in particular circumstances. And then one can see the extent of the bus lane on page 544.
So the order was made on the 10th of January and nothing happened. I could still drive up and down as I used to before making a modal shift and mounting my bicycle on the 11th and 12th and 13th. There's an interesting question as to whether on the 24th, were I so to do, I would be in violation of these arrangements, but there were no signs available.
Yes, correct.
So at the 3rd stage, I couldn't be prosecuted.
Correct.
So I could do it on the 11th. Or I question mark whether I can do it on the 15th, but I needn't worry because they can't catch me.
They can't catch you, my lord. But that, again, I say that's not the end of the
No, but
question.
that is the correct analysis.
But
making, in effect, enforcement.
Can it be
3
enforced?
stages, really.
Yes, and I accept because the signs are not put out, it cannot be practically enforced. I
Yeah.
accept that.
In relation to each of the first 4, is it correct that it's just signage that's required to make them effective, or was there some construction work required as well?
Well, in practice, my lord, there would have to be construction work because it's all part of the wider scheme.
Well, this
So-
is why it's a part of the wider scheme, which embraces other kinds of public realm improvements,
Yes.
etc., etc. And if one looks at the plan of the 36 metres of bus lane that is contemplated by this order, presumably that there would be other works to the road surface as opposed to simply putting up a sign.
Of course, my lord. And for when one's putting in a one-way, of course, there would then have to be attendant amendments to junctions, etc., in order to facilitate that. So, yes, there would have to be physical works and signs in practice.
So it may be in a pious hope that on the 24th of January, a rogue, towed motorist would go up and down, because even if they hadn't got the signs there, you aren't ready for it. You're not going to put the signs there because you're not ready for it. So
well, yeah, well, that may be the case, but as I'll come to, the putting out of the signs is not what brings the order in.
No, that's why I distinguished between making effect and enforcement. I said there were 3 stages.
Yes.
That's why I said I could do it on the 14th. I mustn't do it on the 24th, but I could get away with it because you hadn't done the signs.
Yes, and my lord, the council has a discretion as to when to make.
Yeah.
At that point, it must, when it makes the order, it must know when the order's coming into force.
So you say, but that's not the subject matter of this challenge anyway.
Well, it must. Well, my lord, in my submission, it's important.
Right.
Anyway, I'll come on to that in a moment. There was then the TRO 2, 546. This is the one-way.
So which page 5?
So
546.
Again, having been brought into operation on the same date, that's paragraph 4. And
That's a particularly interesting one because it can't possibly be said that the day after it comes into effect, if that's the right phrase, on the 24th of January, traffic can only drive down that street one way. That's just nonsensical, isn't it?
But look, the point is, I accept they're not enforceable.
Well, it's not so much not a question of enforcement as in criminally enforceable. It just isn't there. It's not a one-way street yet.
Well, except that the council has no discretion as to when it can put out the signs. Once the order is made and brought into force, under the regulations, it's actually required to put the signs out before it's brought into force.
Well, you'll take us to that in just a second.
I will, Mel.
My point is, it's not just a matter of signage. It's fundamental to a one-way street that people are told to drive down that street one way, and they're not yet.
Yes, my lord, and that is at the heart of the Heron and Parking Adjudicator case law, that you can't be prosecuted for an offence you don't know about. You have to have reasonable notice. But my point is that once you have made the order and brought it into force, you cannot then, that has implemented the proposals, because by law you are required to then put out the traffic signs in order to make it enforceable.
Well, 18 says, where an order relating to any road has been made, that has happened here, it happened on the 10th of January. The order-making authority shall take such steps as are necessary to secure, before the order comes into force, the placing on or near the road of such traffic signs as will provide adequate information. And the question will be whether that means they can't say it comes into effect, it's made and it comes into effect and it should be a one-way street before they put the signs in, or whether into force means something different there, which is really looking at enforceable as opposed to has effect.
Well, may I come on may I finish with the TRO?
Yeah, go on.
The very short point is, my lord, I don't think I need to go through all 4 of them, is that what the TRO 1 to 4 did was that they instituted the bus lane, a one-way system, and regulation of turning movements.
Yeah.
What they did not do is make changes to parking in those areas, so remove parking from the bus lane. That was part of TRO 5. And nor did they institute any measures in the area of what was the proposed cycle lane.
So just help me, if I can't go down the bus lane, how can I park in it? If I'm driving, I know I'm erratic, but I shouldn't be in the bus lane in the first place. If I can't drive down it, I can't get to a place to park, can I?
Because, my lord, if one turns, because the underlying TRO that's still currently in existence, because TROs 1 to 4 have not revoked any existing TRO.
Right.
So it was TRO 5 that revoked the current allowance of parking in this area. And if I show your lordships that, it's a SB 10, supplementary bundle 10.
Yeah.
Starting at page 165.
Yeah.
This was so one can see that this is the order that amends parking and waiting.
And where's that?
Well, so the title is on page 165. One then goes to paragraph 3. Prohibition on parking.
Yeah. But it doesn't matter. My point is different. There are two things. I have to drive there and I have to turn the engine off.
Yes.
This allows me to turn the engine off, but I can't drive there.
But my lord, if one turns to
I mean, I park all over the place and then I realise I'm not allowed to. But
yes,
sometimes I can't even get to where I would like to park because I'm told it's a one-way street.
but my
There are
lord,
two things in life.
yes.
You haven't seen me drive, I promise you.
Well, look, the short point is so 174 is the revocation of existing orders.
Yes, I understand that, but you're not engaging with my point. There are two things. Is there a place for parking? Answer yes. Can you access it in this marvellous Harrogate system? No, because you can't go down the one-way street if that were in effect. You seem to be saying because of the parking thing being allocated, that means you can't have the one-way street. But the answer is it would make the parking redundant because you couldn't get there. I don't see why it's so critical.
No, but, so without TRO 5, one has one TRO saying this area is a bus lane.
Yes,
One also has another TRO saying you can park in the area of the bus
yes,
lane. So you
exactly.
have two conflicting orders.
No, you've got one saying don't drive down there and another one saying you can park. But since you can't drive down there, you'll never be able to be in a position to park.
My lord, well, my submission is more of an in-principle one. When one looks at the statutory scheme, which I'll come to in a moment, it is clearly driven towards clarity and that the underlying traffic regulation order in place should match the signage on the road. Well, if it were possible to have overlapping TROs which were inconsistent with one another on the books, then it would be open to the local authority one day to say, oh, well, this is a bus lane, put up those signs, and then a couple of days later say, actually, it's not a bus lane, we'll switch to the other TRO.
But they don't even have to do that, actually. All they've got to do is come at night, take the bus lane signs away, and then I can drive, and if I park, there's nothing to stop me.
Exactly. But you know, and it could have made that order.
Anyway, I don't think we need to spend time on this.
So, my lord, but the short point is that it was TRO 5 which was revoking, which was necessary in order to revoke the ability to park.
You say in practical terms, you couldn't have T1 to 4 without T5.
Yes.
And T5 wasn't being made at the time.
Yes. And equally, it was T5 was necessary to deliver any measure south of the bus lane.
Yep.
So to deliver the cycle lane.
So the TRO 1, which is the bus lane, couldn't be made in practical terms effective until the parking bays were removed.
Well, if one had, if let's say the signs have been put up.
I'm not. It's not actually. That's badly phrased. It's not so much the parking bays removed. The TRO which allowed you to park there had to be revoked before the bus lane could ever be, in practical terms, effective.
Well, one would. Let's say that the road, the signs are put up and the bus lane is made obvious in practical terms, but there's still so then you've got that's supported by the TRO, which says this is a bus lane. You would also have there would be a conflicting TRO, which allows you to park in the bus lane. So someone who parked in the bus lane would be potentially guilty of an offence for being in the bus lane, contrary to the bus lane TRO. But presumably would say, well, hang on, I'm acting in accordance with another TRO that's in force, which allows me to park there. And so it would lead to, in my submission, legal confusion.
Yeah, so it wouldn't happen. That's the point. You wouldn't bring the bus lane into practical effect. I'm trying to stray away from any of the specific terminology. Without the existing TROs, which might have allowed for all sorts of other things, being revoked. To avoid that very inconsistency and problem you're talking about.
Except that, of course, once you have made the TRO and brought it into force, you are required.
Well, then you're straying into the language of bringing into force.
Well, then,
and then you've got to work out what bringing into force means,
yes,
actually. Whether it means the date on which it takes effect or the date on which it becomes criminally enforceable.
And I think
that's the question.
The question.
But I didn't realise that was what was raised in this case.
My Lord, it is, because once one understands what the effect is, that the TROs implement, they, as a matter of law, implement.
Well, that's what you keep saying,
yes,
but we haven't yet got anywhere near the law. Anyway, we won't take you out of your stride anymore. We'll let you get on. So you've got the 4 things that you say shouldn't have been looked at, should have been looked at and weren't.
Yes, my Lord.
You've now taken us through the TROs.
Yes, my Lord.
So where do you want to go
next? I'm
going to
come back. I'll come back to the justification for making the orders under ground 3.
Yeah.
And so then, and I'll deal with the judgment of the judge below under the original grounds. So if I could then come to the legal content of the law.
Yeah.
And, my Lord, focusing on the legal effect of the TROs. So if I could turn to tab 3 of the authorities line. So starting with Regulation 16, page 68.
You don't have section 2. I mean, the Act, you've got to read the regulations in the context of the Act.
Yes, my Lord.
Section 1 is to make an order where they think it is expedient to make it. It's Regulation 2 that says what kind of orders they can make, isn't it?
Yes, my Lord.
And I think it's in the judgment, isn't it? You need to understand the regulations and what the regulations are doing in the context of what law is doing. This is paragraph 4. TRO may prohibit a wide range of activities, but can't impose a speed limit. Okay. So they've got a power to make an order, and the order can make restrictions. Presumably you can't drive down this road because it's a bus lane,
yes,
or you can't drive down this road, it's a one-way street.
Yes, ma'am.
And then it's a criminal offence to do that which is prohibited.
Yes, ma'am.
Right.
So, turning to the regulations, apologies, my Lord, I didn't start writing. Turning to the regulations, Regulation 16, page 68 of the authorities bundle.
Yeah.
So entitled Making an Order and Bringing it into Force. Well, it's clear from this regulation that an order may come into force on a different date from that which is made. My Lord, I'd highlight subsection sub 2. No order shall be made after the expiration of the period of 2 years, beginning with the date on which a notice of proposals relating to the order is first published. So that allows an order-making authority to publish the order, gone through the publicity exercise, considered it, and then wait for a period of up to 2 years before making the order.
Yes. That's the consequence of the prohibition that you can't go beyond 2 years, is that you could wait. Yes.
Yes. So then we have the requirement that it cannot come into force before the date on which it's intended to be published.
Yes. These are setting outer parameters. You can't make it
Yes.
before all the objections are in. You can't make it after 2 years.
Yes.
And you certainly can't make it a criminal offence
Yes.
by bringing the order into force before it's made or before the notice is published. That's what those are all about.
My Lord, yes, and then understood with Regulation 17. So Regulation 17 is deals with the publicity of the order, and it requires certain particulars to be included. That's 2 Roman 2.
But presumably, because that comes after the making of the order and it's in a separate document, the order is not invalid if that doesn't happen.
That if
The order, the making order, is not invalid because those are things that happen afterwards. You've made the order, and some days later you may have to do other things.
you may, yes, my Lord.
But that can't make the order invalid, can it? Because you've already made it.
My Lord, it may be a reason for quashing the order.
Well, how can it be if you've got 14 days to make it? Are you saying it's valid from the day it's made and for the first 14 days? But on day 15, when you suddenly realise they haven't published the notice, it becomes invalid, and if so, from when?
Well, my Lord, scope under the Parent Act for challenging the procedures. So, well, I'm going to park that for a moment. I'm not sure it's essential for my submission, which is to take your Lordship to the point that by the point of publication, it must have been decided what date the order is to come into force.
Right, okay. Anyway, so
That's
we leave
the
that to
short
one
point.
side, whether the making and the publication of the notice of making are separate, yeah?
So
and it's got to contain the particulars in parts 1 and 3.
1 and 3 of Schedule 1.
Yeah.
Part 3 of Schedule 1 includes paragraph 11,
Yeah.
which is on page 93. The date on which the order is to come into force.
Yeah.
So, my Lord, although the regulations do not expressly require the order itself to state the date on which it comes into force, in my submission, the date on which the order comes into force would be practically part of the decision-making process.
What does that mean?
Because, my Lord, the order is being made for a particular purpose. It's clear that the order-making authority has to know what date it is going to be brought into force at the point of making, because it's one of the particulars that is required once it's published,
Yeah, but
the order.
yeah.
And it's clear from Regulation 16 that the date of making will not necessarily be the date on which the order is brought into force.
Right, so what is the submission? That failure to specify in the notice published within 14 days renders the making of the order invalid.
No, my Lord, no.
Right.
It's at the point of making the order.
Mm-hmm.
It will be decided when the order is coming into force.
Why?
That's
They
not-
could be day 2 or day 3 when they publish.
Well, my Lord, I accept it's not expressed in the regulations, but the fact that that is a detail which is required to be published, in my submission, supports the view that it is the order itself will have to make clear when it comes into force, because otherwise these orders might be in place for 20 years and they establish criminal offences.
If there's appropriate signage, yeah.
And so it will have, there has to be signage and there has to be the underlying order. So anyone looking at whether the offence has been committed will have to know, was it in force?
Would it satisfy paragraph 11 to say this order will be in force after the 3rd of March 2026?
And then leave it flexible?
Yeah.
No, in my submission, no, my Lord.
Because
the date on which the order comes into force. So in my submission, it's certain as to what date this is coming into force.
What if you don't know? You don't know, for example, whether you're going to get funding. Could it be the day or 14 days after the approval of funding? Could it be 14 days after the completion of the construction works?
Or 14 days after we've erected the signage?
Again, in my submission, no, my lord, because, again, this is legislation which is establishing a criminal offence. And if one...
But the criminal offence is conditioned on the signage. So in that example, there wouldn't be the mischief of somebody committing an offence without knowing about it. You'd be simply saying, I'm going to, because I need the signage in order to enforce the provisions, the effect of what I'm deciding in making the order won't come into effect until 28 days after all of the necessary signage has been erected.
My lord, no, in my submission, that's not what the regulations are driving at. They're driving at certainty as to when this order... It's like, for example, bringing into effect regulations. So you might have draft regulations which then have a date on which they are brought into force by Parliament or the Secretary of State.
It could be an event. On the dissolution of Parliament.
Well, in my submission, no, it would have to be the date on which the order is to come into force. And I suppose, I would add...
But if by come into force means something which is capable of enforcement, criminal enforcement, on the authorities, that can't arise until the relevant signage is in place to put the motorist on notice that they're, or indeed the miscreant cyclist who's cycling the wrong way down a one-way street, that they're committing an offence. Because in the real world, as in this example, TRO may be just one ingredient in a much wider scheme of public realm and other improvements. So the difficulty in that context may be that you don't know, as here, that you've got all of the other ingredients that you need in order to make a satisfactory scheme.
Lord, for that reason, I underlined Regulation 16.2, page 68, which allows for that 2-year period. You've got up to a 2-year period, so you've publicised, you've considered, and you've got a 2-year period until you make them. And you could make...
But this is the publicity exercise.
This is the publication notice.
This
it's
is the
not
publicity
the order.
exercise. So the effect of your submission is, as I understand it, as I understood it earlier, it must be part of the decision-making process, not just to decide whether it's a good thing to make the TRO, but also to decide the date on which they're going to be brought into force, and to publicise that within 14 days of the decision to make the TRO.
Yes, Lord.
And that, I'm just putting to you, in the real world, creates a great deal of inflexibility for a highway authority who is trying to actually deliver a much wider scheme of renewal and improvement.
Well, in my submission, it doesn't, because there's sufficient flexibility before the order is made. Because you can have gone through the publicity process. You could have reached an in-principle decision that this is what we're going to do. But we're not actually going to do it, make the order, until whatever ducks are in, other ducks that need to be in a row are in a row. So there's sufficient flexibility, but the flexibility comes in the decision-making process prior to the actual making of the order.
The problem that you've got is that it doesn't say anything about the order must include the date. It says the publicity notice must include the date.
It does, but of course the publicity notice has to be issued
long after
within
the order is
14
made.
days.
For 14 days it's been
within
sitting
14
there.
days.
That's why one wonders whether the regulations about the publicity are concerned with another thing. If you go to 1 and 2 and 5 of the Act, they're changing the road arrangements and they're making it a criminal offence not to follow the new arrangements. So you've got the order that says these will be the new arrangements. It's not fair for people to be penalised without knowing that. So there are publicity mechanisms in place, and indeed you're not going to be able to enforce unless signage is there.
Yes, my lord.
But these are designed, on one analysis, to be protective mechanisms for the motorist, not preconditions for the validity of an order.
But my lord, the protection from the protection from the motorist comes from being absolutely clear on when the order comes into force.
I bet he doesn't care. I mean, most drivers will look at the thing and say, oh gosh, it's match day, I can't park outside the Emirates. Sorry if you...
Happens to be my team, my lord. But
well, there we are. But I mean, I've had a parking fine because I hadn't realised it was match day, and I thought, well, they should have told me. And I walked down the end of the street and I looked, and they did tell me. Now, I'm a lawyer. I could have looked up the Highgate, Highbury, Arsenal match day order 1832, but I didn't.
Well, but that's the point, because in order to have the offence, one needs the signs and one needs the underlying traffic order. And unless one knows from the order whether it's in force or not at a particular date, then how could the offence be proven? And that's again why one can't have overlap. If one could have a number of overlapping TROs, and it's up to the whim of a council officer as to whether they put up signs to support one TRO or to support another on any given day, then that would lead to a very significant lack of clarity as to what the legal position was, because a motorist would say, well, yes, the sign said that, but actually there was an underlying TRO that allowed me to park there.
Well,
and he wouldn't be in breach of that TRO, but he would be in breach of the one that said don't drive to it and read the signs.
but that all bleeds back into the point I was trying to put to you earlier, that in fact in a world like the world that this case inhabits, it won't be possible at the time when you approve TROs 1 to 4 to be dogmatic about the date when they're coming into force, because they dovetail with the provisions of TRO 5, which means that actually it's artificial to say that as part of the approval process in TROs 1 to 4, you have to specify the date they're coming into force in the way that you're describing, when the truth is that they'll all come into force as and when the signs go up.
Well, but Lord, that certainty can be achieved by making the order when you know they're going to...
It can be, but is it legally required?
Yes.
Could you not have an order that said, a publication notice that said, this notice will come into force when Traffic Regulation Order 5 comes into force? Why can't you have that? And then your ardent motorist, not reading at the same time he's driving, will have checked that, and you say, I've got them. TRO 5 is in force, and there aren't any signs. I've got a double defence. I'll get away with this one.
My Lord, in my submission, because of the need for certainty as to whether the order is in force, it would, as a matter of, it would require a clear date on when it's coming to force on the face.
But as a motorist, the only sure indicator that there is an order in force is the signage, isn't it?
Yes, my Lord.
Yeah.
Yes, but then of course whether.
I mean, I don't sit at home consulting what orders may have been made before I decide on my route.
Well, you need the order and you need the publication notice. You need two pieces of information, two documents. You wouldn't know anything from the order about the date.
Well, in my submission, one, this order did have a date, and in practice the orders do have dates.
Yeah, but they don't have to.
Well, in my submission, they would, in order to know when it has come into force, if that is different from the date on which it's made.
Can we just see the order you said? You say in this case the orders do specify the date on which they come into force.
Yes,
Can we just see that?
Yes, it's the back of the core bundle.
Is it what you showed us earlier, the 24th of January date? Is that
The
what you
25th of
say?
January. So they use the phrase into operation.
Yes.
Which I understand was part of a template used by this authority.
Right, but that could never have been actually the intention, can it? Because there was no way the signage, because there's an obligation to put signs up before it comes into force,
Yes.
Regulation 18. It doesn't say they don't come into force until the signage is up, I think.
Exactly.
But there's an
What
obligation.
what it says is it will come into operation.
It says come into operation. Now, my learned friend in the skeleton for the High Court accepted the orders were in force. It was then the judge who raised the issue between the difference between into operation and into force.
Well, even enforced can mean two things. Part of the law of England and Wales, enforceable in the criminal court of England and Wales. There could be a third thing. They've got to specify a date, the order having been made, on which it becomes part of the law, even if it's not yet criminally enforceable. And that may be another issue, but you aren't saying that the order is invalid because the subsequent publication notice did not carry a date. That's not your argument.
No, my lord. The publication notice carried the same date into operation, on the 24th of...
But you haven't challenged the validity of the publication notice.
Because in my submission, it's clear that the orders have come into force, they are in force, and that is in the publication notice, the new tab 14 supplementary bundle.
Well, they've definitely been made, haven't they?
They have, ma'am.
There's no doubt that they've been made. They definitely can't be the subject of a criminal prosecution, can they?
No, my lord, that's correct.
So the question is, what is the status between having been made and when finally the signs go up in Harrogate?
So, my lord, in my submission, we have the order, it says they come into operation on a certain date. We have the publication notice, which uses that phrase, and we know that one of the elements of information required on the publication notice is the date the order comes into force.
Yeah.
It has a particular date. And in my submission, in the context of the statutory scheme, the phrase into operation is synonymous with into force.
And what does into force mean?
Into force means when it comes into legal effect.
So the council's in breach of Regulation 18 then, you'd say?
Yes, my lord.
Is there anywhere in the regulations a provision for amending the date on which it comes into force?
My lord, no. And there's no provision in the regulations for inserting the date on which it comes into force.
For what?
For inserting a date on which it comes into force after it's been made.
Because it can't be an unusual situation where a traffic regulation order, in order to be enforced, requires construction work. For there to be a delay in construction work that was unforeseen,
Yes.
requiring the date to change. What
Yes.
happens in practice then?
Well, then, in practice, my lord, the construction works would take place, and then the traffic signs would go up, and there would be a space in which the order, as we have here, the order is in force, but it wasn't practically enforceable. And equally, there will be situations where traffic signs might have accidentally been taken down, or the wrong traffic signs accidentally put up. But that doesn't obviate the requirement to put the traffic signs up to bring the order into practical effect.
Yeah, so we do have the position in this case, on your case, that on the 24th of January there was a traffic regulation order in force
Yes.
requiring this particular piece of tarmac to be used as a bus lane, and another traffic regulation order in force saying it had to be used as a parking space.
Yes, so that's relevant to ground 2. But the other point is, because it's been made and brought into force, the authority has no discretion as to whether to bring it into practical effect.
That's another concept, now, practical effect. What does that mean?
As in, sorry, to put out the traffic signs. Because the traffic signs are required under Regulation 18
No, they're not.
to put before an order comes into
They've got
force.
to secure they're there before the order comes into force,
Yes.
and that's the whole question of what
Yes.
enforce means.
Yes, ma'am.
And that might, I understand the wording is clumsy, and if you weren't thinking about a criminal statute, if you're thinking about something that regulates a planning permission, you'd say it's enforced from the date on which it's normally made, or if it's not that date, a date that's stipulated. But here, the whole purpose of these things is to regulate traffic, not for the purposes of the greater good of mankind, but to make it clear that if people don't do it, they'll be prosecuted. So one does wonder whether the particulars and the coming into force are not concerned with the making of the order, but are concerned with the enforcement of the order. And that there isn't a halfway house, as I've been suggesting, of first you've made it, then it's in effect, and then you enforce it. That in fact, when they use the words enforce, and when they require dates, they're talking about the dates of criminal enforcement. And that fits with 18, because hand in hand with the date of criminal enforcement is the signage.
Well, my lord, the phrase "in force" is used in same phrase is used in Regulation 16, used in Regulation 18, and used in paragraph 11 of Schedule 3. And in my submission, those are the same dates.
Which phrase?
So the phrase "into force."
Where is it used in 16?
So
Into force 3?
So 16.3, no provisional order shall come into force for the date on which the OMA intend to publish a notice.
Yes, well, that can mean no provision of the order shall criminalise somebody on a date before the notice is published.
Well, we then, my lord, have it in Regulation 18
Yeah.
and paragraph 11 of Schedule 3, which is page 93. Part 3 of Schedule 1. The date on which the order is to come into force.
Right. But the purpose of this submission, just so that I've understood it and don't lose sight of it, because you're not challenging the publication,
No.
is to say that there was a period of time when the order had been made and was legally in force, even though it couldn't be criminally enforced. Is that it?
Yeah, so at the present time, the order is in force. In my submission, there's no there's no difference between the use of the phrase "into operation" and "into force."
Yeah.
And pursuant to Regulation 18, the order-making authority has an obligation. It had an obligation to put the traffic signs out before the 24th of January 2025. But it has no discretion. It can't say, well, I'm simply not going to put out the traffic signs.
So it's a duty, not a protection.
It's a duty on the, once the order is made and in force, the duty is then to put out the traffic signs.
Yeah.
And my lord, if I turn to Heron, which is at tab 4 of the authority law.
Yeah.
This is the case just confirming the enforceability of a TRO, i.e. you won't be liable for breach unless there are signs put out. That is dealt at paragraph 35 onwards, page 106 to 107. Those cases are dealing with solely that point. A TRO, you can't be convicted for breach of a TRO unless you've been given adequate notice. It's 35 to 36.
Yeah.
But what they're not saying is that it is the traffic signs that bring an order into force.
Yeah.
Now, it can't have been the council's intention in making these orders that they would come into force, in your sense, on the 24th of January 2025, can it? That's just not remotely possible.
My lord, I don't know why the date, the 24th
No,
of
but it
January,
can't
is
have-
taken.
it
But
can't
yes,
have been.
it would be surprising, my lord, given they had to republicise TRO 5. Maybe the council simply didn't appreciate the effect of the statutory scheme. So,
It's not easy to see how that makes any difference to the validity of the order.
because, my lord, if I am right that there is no discretion, once the order is made and in force, and there is no discretion to, what I say is bring it into effect, but to put out the traffic signs, that has implemented, as a matter of law, part of the revised Harrogate Station Gateway Scheme.
It has made a traffic regulation order, which is in force, which is part of what the scheme is intended to bring about eventually. Yeah.
Yes, but I say that the November 2023 resolution was subject to provisos, one of which was a satisfactory public engagement outcome. So the implementation of the scheme was not certain at the date the TROs were made.
So, sorry, you finished.
Yes, well, and so it was unlawful to make the TROs which implemented.
Right. So there wouldn't be a problem on your analysis if the TROs here had said they will come into force on the 1st of January 2026. There would be now, but there wouldn't have
There
been.
would be now.
a
Well,
month ago.
then the question would be what had the council satisfied itself that that was a rational date?
Oh, but that's a separate
Or-
question.
That's a separate, yeah.
This is a virus question, so there's no
Yes.
point going off on an issue that is not the question my lord is asking. Had they said the 1st of January 2026, there would have been no virus issue on this matter.
Well, there still would have been, because what they are setting in train there by making the order, albeit having a longer date to bring it in force, is an inevitability, because it comes into force in a year's time, and before that time they have to...
It preempts the public engagement that you say must happen. So the whole purpose of this is to say that there has to be public engagement before anything that's a necessary element of the scheme is put in place.
It's the particular character of the TROs, my lord, because if this had been a planning permission, the council would have complete discretion as to whether or not they wanted to implement it or not. In my submission, there is no discretion under the statutory scheme once an order is made and brought into force.
I've got that point, but the point is that wouldn't get you home, because your point is that the public engagement requirement in the resolution attaches to the scheme, and nothing can be done to implement the scheme or implement it in part. And the making of the TROs 1 to 4 did implement the scheme in part by bringing them into force.
Yes,
That's your case.
that is.
Yeah.
So actually this debate about what enforce means is irrelevant, because on your case, the making of the TRO implements the scheme, because there's an obligation to bring it into force, and you've got to publicise that within 14 days. So there has to be a date
There has to be a date.
provided within 14 days of making a TRO. Therefore, the making of the TRO is implementing the scheme. That's your case, is it?
Yes, my lord.
Yeah.
And it wouldn't really matter when it came into force. Would it?
Oh no, it wouldn't.
Yeah, because if you're going to have public engagement before you do something to implement the scheme, and if making the order is implementing the scheme,
If the
it
making,
was unlawful on the very first day. You don't have to wait for the end of the 14-day period for the publication of the notice. You've gone straight away and said, no. They cannot, they have disbarred themselves from making an order until they've got public engagement.
So the whole point breaks back to what
The
the
resolution
reasonable
means.
reader is to understand from the resolution that the council
resolution
passed.
of council.
Yeah.
Exactly. Yes. But my lord, what I would add in terms of my submissions of what the regulations require once the order is made is that in order for this council to revoke a TRO once made, these TROs once made, it has to make a fresh TRO and go through the whole publicity process, etc. So there's no ability, there's very limited ability under the regulations where you can short circuit that approach.
I'm not with you now. We're on ground one.
We're on
Public engagement is required before either the making of the order or the publication of the notice.
My lord,
And that's your case, and that depends on the wording of the resolution or how we interpret it being the embodiment of the reasonable person.
yes, my lord, apologies. I'm coming back to the statutory scheme just
Oh,
to make one
right.
additional point, which is that, so Regulation 20, which is in tab 3, page 73.
Yeah, hold on. Yeah.
So this gives an ability to revoke orders in limited circumstances. So, for example, so 1A, the order has been made where required to publish, the authorities failed to comply with the publication requirements, such as unable to do so, and no provision of the order has come into force, then in those circumstances there is a special ability to revoke that order.
Isn't that against you? Doesn't that mean that the order is effective? That's why you've got to revoke it. If there was a failure to specify, for example, the date, it's not that it's invalid, it's that there's a power to revoke. That all reinforces the idea that the making of the order is a distinct legal act, isn't it?
Well, sorry, yes, the making of the order is a distinct legal act. So, my lord, if there are certain circumstances, if this authority had failed to publish it and the order had not come into force, then there's a narrow scenario in which it can, that's the scenario in which it can make a revocation order and not promote a new TRO in order to revoke these ones.
It's a discretion. That rather sounds as if what the regulators meant was this: you make the order, full stop. You publish the notice and you give the date, full stop. If you haven't done that, gosh, what do you do next? Answer, you may do something else. And that thing may be revocation. Or you may say, no, it's all right, we've done it now, still there, still in force, and we've got the signs up, and we've built the tarmac.
Yes, my lord. But my point is that...
That's against you then, isn't it?
Well, I don't accept that, my lord, because my point is that once you have made the order, you've published it and it's in force, as these orders. That is the situation with these orders. The only way of revoking these orders is to go through a whole new TRO process. They cannot be revoked under this mechanism.
I'm not following you on this. I don't understand what you mean, and I don't understand the significance of it.
So, well, once made and enforced, and the order and the order's been published.
Yeah.
The only way of revoking that order is to go through is to promote a new TRO. Because this regulation doesn't apply where an order is where there has been compliance with regulation 17.2.
It's going to apply on your submission in a vanishingly tiny number of situations, isn't it? Because your earlier submission is that the date of the order needs to be decided and it comes into force within the 14-day publication period. Whereas, if in fact coming into force means the erection of signage to give legal effect, criminal law effect to the order, that may provide a much greater degree of wiggle room to deploy this discretion, mightn't it?
Well, in my submission, my lord, the provision of the order has come into force comes back to that date, which I submit would in fact be on the face of the order, but it's certainly in the publication date.
But if you look at 20, this regulation applies A, where the authority is required to publish a notice of making. That's this case. B, if the authority has failed to comply with regulation 17.2 or is satisfied that it will be unable to do so. You say it's not this case, but we're into that kind of territory. And C, no provision of the order has come into force. That rather assumes that if there was a date, or if they failed to put in a date for force, that the paragraph applies. Then you go on to see what they can do. Where this regulation applies, the order making authority may, not must, may, A, make a revocation order, the sole effect of which is to revoke the previous order. B, a replacement order, the sole effect of which is to revoke the previous order in whole and to reenact it with, and a new concept here, a different commencement date. Or C, a delayed reenactment order, which has the effect there. So this rather assumes as if you make the order on 16, you publish it with a time. If you haven't published with a time, or you can't meet the time, or you can't specify the time, then you can go back and change the date, or you can revoke the order.
Yes.
So,
But in those narrow circumstances, my lord. But
in
where
narrow circumstances.
yes, but where the order has come into force, then you can't avail yourself of this regulation.
But why isn't it satisfied that you'll be unable to do so? It couldn't. That's why I'd use the word operation, they would say, imagine.
Well,
They
Well,
couldn't say it's going to come into force. They hadn't got the money from the Yorkshire people, had they?
well, in my submission, there is no different. The term into operation is synonymous with the into force.
So if they left out the word in operation, they'd have been better off. So should we just strike that out? Normally in public law you sever to try and make things valid rather than invalid?
Well, no, my lord, one couldn't, because of course, in order to have a valid notice, one has to have the date on which it comes into force.
No.
And the
publication has to have the date.
but the publication notice in order to be valid. My lord, here it's very clear what that date is. It's the 24th of January 2025. That is the only reason for that date can be it's the date on which the order comes into force. Otherwise, what does it mean? And we know that the notice of an order requires that date, the date it comes into force. And in my submission, in this context, they're synonymous. And I understand this is the approach that the authority takes, has taken up to this point on all its orders. So in my submission, there's no, I mean, if a challenge had been brought to the notice, and so, well, that's invalid because you haven't got the date on which it comes into force, the answer would, of course we do. It's the 24th of January 2025.
Well, or they might say, well, we don't need to, don't worry. It's not in the Act. The order's fine.
Well, sorry, it is in the Act that it must be in the notice, my lord. If there'd been a challenge to the
We said the order, that's why.
apologies, my lord.
Yeah. Anyway, so I got your submission, but it still turns on the meaning of public engagement and the meaning of the resolution, doesn't it?
It does, my lord.
Yeah.
It does, whether a final decision had been made on the scheme. So, my lord, if I can then turn to ground one.
Yep.
And if we turn to the resolution, which is a SB2.
Yeah. Let me just get ground one and the skeleton in front of me as well. Yep.
So this SB2 is the minute, page 19 and 20.
Yeah.
And once 349 starts with the record that what's been considered is a report of the Corporate Director of Environment. So page 19, halfway down the page. And then one has a bit of detail of the discussion, and then one has the resolution, and the resolution followed that which was recommended in the report. And well, in my submission, properly understood, this resolution made the implementation of the scheme subject to satisfactory public engagement outcome. And in order to understand what that means, one has to look to the underlying report and paragraph 5.2. And one can see that what was a satisfactory public engagement outcome.
I didn't use the word satisfactory public engagement outcome, does it? Unless satisfactory qualifies TRO and public engagement outcome, and you say it does, do you?
I do, my lord. I think the satisfactory applies to the TRO.
Both, okay.
And public engagement outcome. Well, nothing, I don't believe
What
anything.
does a satisfactory public engagement outcome mean then? One that says there's 51% in favour, or that it's legally solid?
Well, my lord, it means if one goes back to 5.2, so what is the public engagement? 5.2 of the report on page 11.
So 5.2, I can't find 5.2.
Yes, 5.2, page.
Oh, yeah, page 11, yeah.
So it's the fourth line down. Period of public engagement, as well as any TRO public consultation required. It's also proposed to understand the level of public support. And the outcome of this would be reported to the ACC. So the public engagement is, the requirement is to understand the level of public support.
Mm-hmm. It is proposed to that these constitutions, that the design, not the scheme, but the design is supported locally.
So that's the first sentence.
A period of public engagement is also proposed to understand the level of public support. And what's that? The public support for the scheme or for the design?
For the scheme, my lord, because if one looks at the first sentence, so we know that at this point it wasn't certain what the scheme would include.
Sorry, I'm just referring to the content of the revised scope scheme has been the subject of informal discussions. And should the decision be taken to take forward a revised scheme, i.e. the rescoped one, not the original one, it is proposed that the design is supported locally, and then a period of public engagement is proposed to understand the level of public support. Isn't that talking about the design, because the scheme has been taken forward by that stage?
In my
and the outcome on the design would be reported to the ACC.
Well, no, my lord, because the design, yes, the design discussions are happening with the ACC, which is the councillors, but the level of public support is for the scheme. I mean, that will include its design, but it's for the scheme.
But why are they reporting the outcome to the ACC of the public engagement on the design, on the scheme, as opposed to the design? Have they done that before? Discussed the scheme with the ACC?
Well, the scheme was regularly discussed with the ACC.
So they've done that then?
Well, sorry, no, there's been no reporting of the level of public support to the ACC. The ACC there have been informal discussions with the ACC.
Right, so there have been discussions about the scheme with the ACC?
Yes, my lord.
So they've had those discussions?
That's what's reported at 5.2.
Content has been the subject of informal discussion. Okay, so they've had discussions on that. And then if they're going to be taken forward, they want to look at design. And you say the last sentence is actually two things, not just about the design. You say it's about the scheme, and it's got to be reported to the ACC. So why is that relevant to there being a requirement to consult the public generally in the way you outlined?
So, the public engagement to understand level of public support.
Yeah.
And the outcome of that would be reported. But then one looks at the resolution. The resolution is for a satisfactory public engagement outcome.
Yes.
So the decision over whether there had been a satisfactory public engagement outcome wasn't in fact delegated to any person by the resolution.
I've lost the resolution.
Page 15, my lord, is where it's the same.
Because there's lots of things running together here. So the identity of the person or body who decides if the public engagement outcome is satisfactory isn't identified.
It isn't identified. Well, it isn't delegated, my lord. But it matters not for my purposes, because there has been no decision either by the executive or, for example, the corporate directors who are also mentioned in the resolution. Certain functions were delegated. But there's been no decision by the point of the making of these TROs that there had been a satisfactory.
Yeah. And this still depends upon that public engagement outcome preceding the TROs, though.
Preceding the implementation of the scheme.
Preceding the implementation, which you say means preceding the TROs.
Yes, my lord, because of their legal effect.
There's a separate statutory procedure for consulting in relation to the TROs, isn't there?
Yes, my lord.
And that was carried out.
Yes, my
And
lord.
there's no complaint about that.
No, my lord.
So what would be the purpose in a sort of double public engagement exercise? One, before you make the TROs, going through the statutory hoops for that. But then before you make the TROs, also going through some separate public consultation exercise.
Sort of obviously the committee were very clear that it should be done in addition. And that's in the
Very clear by...
because 5.2 of the report, that is the proposal. It's clear that it is in addition to TRO public.
This is not a proposal, this is just a setting out the constant undertaken and what the officers suggest. Yeah.
Yes, my lord. And that's then reflected in the resolution. A wider consultation. So the TROs themselves deal solely with the traffic management aspect. So the bus lane, the one-way, the removal of parking. But the wider scheme, of course, includes the public realm measures. There's relevant works, for example, in Station Square, impact on townscape, impact on heritage. So it's a wider exercise, the consultation on the scheme versus a TRO publicity exercise.
Just going back to the words of the regulation, I understand your legal case about what you think implementation means. But we're looking at what this person thought he or she was doing, or what this committee thought it was doing. And it appears, according to the other side, that the person concerned thought that there was a difference between PRO and public engagement outcome, and wasn't suggesting that the public engagement outcome precede the TRO, and therefore when it says the scheme to be implemented, it wasn't saying you can't make the TRO because that would be implementation, you must have the public engagement outcome first. Whether if he were to do a legal essay he would have done that, that's not what they say this resolution does. Isn't there some force in that?
In my submission, no, my lord, because what the effect of the TRO is a matter of law. And if I'm right that it has implemented, to go as far as...
No, but my point is a different one. My point is he wasn't using the words there in their legal sense. He might have been using them in a different sense, and we do that in ordinary conversation and in documents. So if I intend something to be, it's no good saying, well, you shouldn't have used that word. You should have used a different word, because if you'd been a lawyer, you'd have known that word means something different. So then we have to work out whether the intention was, before they made the TRO, that there could be no TRO made until the scheme had been reconsulted upon.
Well, actually, until there had been public engagement, because one of the points you haven't addressed yet is what is to be understood by public engagement.
Yes.
We've seen from the May report a whole variety of different ways in which the public, either individually or through civic society, were engaged by the council in this process. And maybe said against you that actually going through some formal Sedley Principles public consultation exercise was not what was envisaged by public engagement, which talked about a continuation of the work that they had already been undertaking.
Well, just to deal with that point, I rely heavily on 5.2. The purpose is to understand the level of public support.
Well, that could be done by going to the Harrogate Society and saying, do these proposals still have your support?
Well, first, in my submission, that hasn't occurred. But second, there would still have to be a decision by the council that there had been satisfactory public engagement outcome. So even if I'm wrong about the exact character that this would have to take.
Yeah, but the question is whether it has to go before the TRO or after.
And in my submission,
if you're right, that there has to be some decision by the executive, since it hasn't delegated it, on a separate requirement, public engagement outcome, then you may be back here spending thousands of pounds again, challenging a decision. But that, you're not challenging the decision, you're challenging the making of the TRO.
yes, my lord.
And if that's not required to be preceded by a consultation exercise on the scheme, because there has been a consultation exercise on the TRO, then this ground of challenge fails, doesn't it?
Well, no. First, the resolution doesn't require the making of the TROs, nor could it, because it hasn't done the exercise. And it still doesn't know what the scheme is.
No, it's making the making of a TRO a condition before it's implemented.
Before it's implemented.
Yeah.
And in my submission, if the TROs, if I'm right, the TROs do implement the scheme.
No, if you're right that when the word implemented was used, it meant legally implemented, or can only be read as legally implemented, then you're right. Yeah.
Well, no, I don't accept that, my lord, because in my submission, what the TROs do or do not do is a matter of law.
Yes, exactly, but we're talking about something else, what this
yes.
person understood by the meaning implementation.
Well,
was he using it in the legal sense, and are you right on the legal sense, or was it used in a different sense? That's all. Anyway, we don't want to go over that. We've gone over that. You've got a number of points that you've got to address. One, you say the public engagement preceded the TRO, or has to precede the TRO. Two, that it means what is referred to in 5.2. And then three, you've dealt with the point that implementation may not be used in, what do you say, the narrow legal sense. And you've dealt with all of those three, I think. Haven't you? Is there any other problem?
So I'm going to then deal with what has happened by way of public engagement and what's relied upon by the defendant. And that's at tab 12 of the core bundle. Page 461.
Yeah.
And this is the witness statement of Mr. Roberts, the respondent. Paragraphs 6 through to 16 set out what he says is public engagement. But if I ask your lordship just to scan those paragraphs.
Did the judge decide that there had been?
Well, I just have to double check the.
If not, then does it matter?
Double check.
My lord, if it assists my learned friend, I think the judge deals with this at paragraph 33 of the judgment.
33.
The determining factor was that engagement wasn't consultation. The judge didn't then go on to, as well as the fact that it wasn't required before the TROs, rather than that what.
Okay, well, I just read paragraph 33. Yeah. Okay. So do we need to go through this then?
Well, it's only that my learned friend relies on engagement.
Or shall we see what he says and then you can deal with it in reply?
My lord, yes. So the short point is that in my submission, the implementation of the scheme through the TRO is contrary to the resolution.
Yep.
My lord, I also argue that the making and bringing into force of the TROs was in breach of a legitimate expectation. And my lord, again, I won't repeat the submissions I've made, but that depends upon my interpretation of the resolution. And my lord, in my skeleton, paragraph 59, I put the point another way, which is essentially that it was irrational to make the TROs which implemented the traffic measures of the RHSGS without certainty that it would go ahead. My lord, again, it's the same point, but in a different way.
Yeah.
My lord, dealing with the judgment below.
So before you move on,
Yeah.
you made the point a number of times that the making of the TROs, as a matter of law, implemented the scheme. I'm not sure you've been allowed to develop that point. What is the core reasoning for that conclusion?
It's because, my lord, they've been made with a date on which they come into force. And there is no discretion under the statutory scheme for the council to then say, well, we're not going to put out traffic signs.
To pull out?
To put out traffic signs. So, i.e. to render it enforceable. It comes back to the point that Regulation 18 require the signs before the order's enforced. They don't.
Yep. It's the 3 stages, really. It's made, the date has got to be there on which it comes into force, and thereafter the signs follow from that and can't be made a way in which it doesn't come into force. Yeah.
Yes.
So you want to look at the judgment?
Yes, my lord. So it's paragraphs 29 to 34 of the judgment.
Yep. Yep.
Starting on page 114. Really, 33 is the meat of it.
Yeah.
And in my submission, the judge has erred by failing to acknowledge the legal consequence of the orders, which is that they do implement the traffic management measures. So that's the first. Secondly, following extensive consultation for November 2023, the resolution does not so imply that further consultation before it's implemented satisfactory TRO or public engagement outcome. In my submission, the judge has erred by failing to appreciate the significance of paragraph 5.2 of the underlying report and what the purpose was of the public engagement.
Yeah.
And even if it were right that that is not consultation in the gunning principle sense, there still had to be a decision over whether there had been satisfactory public engagement. That had not occurred. The third point made by the judge, which is 2/3 of the paragraph down,
Yep.
is that, well, a challenge should have been brought to the November 2023 resolution. But, my lord, in my submission, that challenge would have failed because the resolution was expressly subject to a public engagement outcome. My lord, if challenge had been brought in November 2023 saying you failed to consult.
You say, well, don't worry, it's in the regulation,
That's what
it's in the resolution, that's what you've got to do. Yeah.
And then the fourth is the judge has no legitimate expectation. And my lord, in my submission, that's a misreading of the resolution. And also the statement that the decision on the scheme had been made is not quite correct, because there was this uncertainty at November 2023, in fact, on what it would comprise. There would be this development stage, and then any implementation was subject to proviso.
Sorry, I'm not sure what, I understand the first, what do you mean by development stage? There are certain conditions which we've looked at. What do you mean by the development stage?
So the report set out the elements which the scheme might end up comprising.
I thought we'd gone through that. I thought that although they said that, the resolution that was approved was the scheme as described in 415.
Well, and which would then go through development. It wasn't that exact scheme, my lord. It was that development process. Because that's, I mean, that's what's happened.
So they haven't approved a scheme then?
So, my lord, if one looks... November 2023 report.
Well, it's the resolution, really. That the following be approved, the descoping options for Harrogate. But you're saying no, what's been approved is the working up of
Yes.
descoping. Is that what you...
Sorry, yes, it's the descoping options. It
Right.
can't be a scheme because it's still options at this point.
So what was this authorising? What, further work?
Yes, the further work that was required to descope.
And how did that differ from 415 in the report?
Sorry, my lord, how did it differ?
Well, because the resolution or the recommendation is that the descoping options outlined, and the descoping options outlined takes one back to paragraph 415, doesn't it?
Yes.
Yeah.
And that 415 is might be included in a revised scope. So this
is an approval that those things might be included, and they intended on a different day somebody to decide if they should be included. Is that the submission?
Yes, my lord. And then, but there was still further decision to be made, because of course, acceptable terms and conditions, satisfactory.
No, I've got that.
Yes.
I understand that, but suddenly you introduced the development, and I thought we'd gone through that. And although they'd used the word might be included, there were officers writing a report, and I thought we'd reached a situation earlier on where you were saying that the descoping options that was approval of the scheme, but you're saying no, they approved the words might be included, but somebody has to go away and decide whether or not they should be included.
Yes. And my lord, against that context, and particularly against the context where this is a committee that has been concerned with the level of public support for its proposals, it's entirely unsurprising that the committee would continue to be concerned with the level of public support and would make its resolution to implement proposals conditional on understanding that public support.
Right, is that ground one?
That's ground one, my lord.
So ground two?
Ground two, the short point here is that TRO 5 was not made, but it was necessary in order to bring forward a workable scheme.
For the reasons you advanced earlier,
Exactly.
really, yeah.
And in my submission, it was irrational to make TROs 1 to 4. And as I say, legally implement that part of the scheme without certainty that TRO 5 would come forward. And it could not better its discretion in the consideration of TRO 5, which was to happen at a later date. And then, secondly, TRO 5 contained additional measures for the revised scheme, i.e. that were required for the cycle lane, which were not delivered by TRO 1 to 4. And there was no evidence that the authority would pursue the scheme, the revised Harrogate Station Gateway scheme, without those measures. So my submission was, on that basis, it was irrational to make 1 to 4 without 5.
What about section 31(2)(a), which we have to consider of our own motion, which says that if in fact these orders would have been made in any event, and given that we know that they wanted to make a TRO 5 and they have made a TRO 5, there's no point in quashing 1 to 4 because they haven't made TRO 5 when they've made TR 5.
Well, TRO 5, my lord, is now before the court. The lower
It's valid
courts and
until
the
it's
High Court.
quashed.
It's valid until it's quashed, my lord. I mean, this appeal was expedited. It wouldn't have been possible to get that heard before this appeal. In circumstances where my learned friend hasn't relied on TRO 5 as an additional reason.
No, but we've got to comply with the law.
Yes.
And section 31(2)(a) says we must have our own motion refuse it. And I'm saying if the argument is, oh, you don't know whether they'd have gone ahead without TRO 5, when we know that they've got TRO 5,
Well,
highly likely that the outcome would not have been substantially different.
except, my lord, that in my submission there hasn't been a lawful TRO 5.
Well, there has
made.
been, because
It
they've
hasn't
made
been a
it.
lawful.
Whether or not it will prove to be unlawful depending on the outcome of the court. But where we are, there is a TR5 and it's presumed lawful until it's set aside.
That, my lord, that is correct, but one can't. Well, one has to look at the decision at the point at the date of decision where there was no certainty.
Well, at the date of decision, I mean, it'd be helpful for you to have your understanding of whether or not the modifications which were set out in paragraph 3.2 of the report in December 2024 are reflected in TRO5 as made. Because the decision that was required and was presumably made as a result of that report was that the under 12.1 Roman 2 was that the TRO5 would be modified as set out in section 3 and then steps taken to make it. So as and when the decision to make these 4 TROs was being considered, it was clearly also decided to make TRO5 subject to the modifications in section 3. So hence my starting point, which is it accepted that the requirements set out in 3.2 in essence are reflected in TRO5?
Well, I have to double check if that was exactly what was, or substantially what actually came forward.
But assuming it was, then we've got section 31.2a problem for us, because we say, would they have made 1 to 4? Answer, well, they couldn't make it without TRO5 broadly in that form. Well, they have made TRO5 now in that form, so isn't it highly likely that they would have made the same 4 orders if they'd waited rather than done them before TR5? That's what Parliament has said.
Well, it cannot have been Parliament's intention to allow a local authority to then rely on a subsequent decision, which was ultra vires.
It isn't ultra vires. We don't know anything about it.
We don't know, my lord.
It's actually lawful at the moment.
Well, but in circumstances, my lord, where that claim has not been determined by this court.
So section 31.2a is subject to an exception or a qualification, or needs to be read to accommodate a situation where there's a later challenge to a later measure.
My lord, in my submission, it must be. Because there's a clear public policy argument that the respondent ought not to be able to rely on a decision which is unlawful. Now, I appreciate that hasn't been proven. No, I appreciate, my lord, that hasn't been proven. But in the particular circumstance of this case, and particularly where it's not relied upon by a learned firm.
No, but we've gone through that. We can't get over the fact that it's of our own motion. I know there's no respondent's notice, but we won't cover that ground again. I've got your submission. You've got to accommodate the possibility that something that's presumed lawful might turn out to be unlawful.
Yes, my lord.
Yeah. So that's grounds 2, then, is it?
That's ground 2, my lord, just dealing with the judge's reasons.
Oh, yes.
Paragraphs 36 to 37.
Yeah.
My lord, my submission, the overarching error at 36 is a failure to appreciate the legal effect of the TROs. And it's unclear whether the judge was drawing a distinction between the phrase into operation or into force, but I've addressed your lordships on that point.
Yeah.
And the judge was essentially saying, well, they're not in force because the relevant signage is not introduced. And I've made my submissions on that point.
Yeah.
And then on the benefits of the scheme as a whole, so paragraph 37, the judge rejected the argument that it was unlawful to rely on the benefits of the scheme as a whole when making TROs 1 to 4. My lord, in my submission, because the benefit of the cycle lane could only have been delivered by TRO 5, it was clearly unlawful to rely on those benefits in making orders which would not, in fact, deliver those benefits. And I'll under ground 3, we're going to go to the report, so I can just highlight
So
that.
do you want to do ground 3? It's almost 1 o'clock. Do you want to do ground 3 at 1 o'clock? At 2 o'clock?
2 o'clock, yes.
And you've almost finished because you've covered most of ground 3.
I have, my lord.
All you need to do is take us to the reports and show us that they failed to deal with it, or if you put it, are contrary to it.
Yes.
And that should take you 10, 15 minutes, I hope. Right, well, thank you very, very much. That's been very, very helpful. So 2 o'clock.